Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, folks, that's right. We're back with the Truth Attack. Okay, so I got a lot of material I want to try and get through tonight, so let's just get right into this. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating. So, if you enjoy the shows, the information, the revelations, the discussions, and the guests and the hosts on the other shows on the network, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website, if you're not already there listening through the online radio listening link, and get signed up as a monthly subscribing member, even if it's as little as $10, $15, $20 a month. Every membership counts, and we do need the support of the listening audience to keep the broadcast network operating. So, there you have it, LibertyWorksRadioNetwork.com. And if you want to get fully informed on the maladministration of the internal revenue of the federal income tax by the Internal Revenue Service, the Department of Justice, and the lower courts for the last 50 years, find your way over to taxfreedom.com, start reading and get educated, because the Supreme Court has laid it down that what they've been doing for 50 years is a complete and total constitutional fraud. And if you know anyone that needs any help answering IRS correspondence or answering the Department of Justice in court, send them over to irszoom.com, where you can get the answers to IRS correspondence for $30, $40, $50 a letter with no retainer needed. And you can get the documents to answer the Department of Justice in court using the new Supreme Court decision, which is going to upset the apple cart, to say the least, because it's pretty clear that what the court has done has declared affirmatively from two different perspectives that what the IRS has been doing and what the DOJ has been arguing and what the lower courts have been enforcing since 1985, since 1980 actually, is a complete and total constitutional fraud, essentially amounting to the second plank of the Communist Manifesto in place of anything resembling constitutional taxation. So, we're going to look at a bit at that in the later segments of the show, but right now let's talk about what's happening in the news, which of course is Minnesota fraud and ICE in Minnesota arresting criminal illegal aliens and going after the illegal aliens, just like Donald Trump promised, in a place where there are thousands of them. And of course, today we had Tom Homan announcing that they're pulling out 2,000 ICE agents. He says they've arrested a whole bunch of illegal aliens and they're going to go ahead and pull out. I think that's probably the shrewd thing to do, because as he says, they've already gotten a number of criminal illegal aliens there in Minnesota out. And what everybody is excited about now in Minnesota, everybody outside of Minnesota is excited about, is not the illegal aliens that are there. If the Minnesota people want to have illegal criminal aliens, well, who are we to say that they shouldn't live with the criminals that rape them and kill them and murder them? I mean, other than to the extent that we've already tried to get them out of those neighborhoods. If they want them there, oh well. So what people are really interested in Minnesota now, as I said, is not the illegal aliens. It's the fraud. It's the daycare fraud. It's the transportation fraud. It's the personal care fraud. It's all the fraudulent systems that have been set up to defraud the welfare assistance programs that America offers to try and help people legitimately. But we don't need 100 daycare centers in one building all getting $1 million apiece when there are no kids. Now, ICE doesn't do that. ICE does illegal immigration. So I think what's going to happen is they're going to pull out 2,000 ICE agents and move them to other parts of the country where they will continue to remove illegal criminal aliens from wherever they get reassigned, and 400 to 500 FBI agents will arrive to investigate the fraud, because the FBI does federal fraud, not the states and not ICE. So sure, they're pulling out the ICE agents because that part of the job is done. And it'll buy some political reprieve by ending all the Minnesota violence, which the Democrats are parading and the media is showing on TV to try and prevent people from understanding that ICE are the good guys here. They're removing the criminals. The Democrats insisting that criminals stay in America are absolutely insane. Absolutely insane. It's just a function of opposing anything Donald Trump does. If Donald Trump said your right arm is the most useful thing you have, the Democrats would all cut it off. So it's just, there you go. I think ICE is leaving, but the FBI is coming. So Minnesota may think they're done, but no, it's just beginning. Because the FBI is going to go after the fraud tooth and nail. Bank records, individuals, facilities, buildings, cars, the whole gamut. Houses. And they should. Everything that can be connected to the fraud should be seized and taken. And if anybody objects, they can file in court or respond in court to the seizure proceedings. So, there you have it. That's what's happening in Minnesota. Oh, one other thing, right? Sanctuary cities. Oh, yeah. All the Democrats want to be sanctuary cities. So let's look at that, shall we? Because I've said for a while now that any Democrat politician that advocates for sanctuary cities is violating federal law and can be arrested and tried. Now let's look at that. Here we have Title 8 United States Code, Section 1324, bringing in and harboring certain aliens. And it reads, criminal penalties. 1A, any person who, knowing that a person is an alien, brings to or attempts to bring to the United States in any manner whatsoever such person at a place other than a designated port of entry or place, other than is designated by the commissioner, regardless of whether such alien has received prior official authorization to come to, enter, or reside in the United States, and regardless of any future official action which may be taken with respect to such alien. Okay, now I don't think that section applies. 1, bringing to or attempting to bringing to United States an alien. Now I don't think that declaring sanctuary city legislators, that isn't covered by this one. Okay, so they're safe on that one. 2, knowing or in reckless disregard of the fact that an alien has come to, entered or remains in the United States in violation of law, transports or moves or attempts to transport or move such alien within the United States by means of transportation or otherwise. Now I don't think 2 is violated by sanctuary city legislation passed by a Democrat politician. So we're not going to talk about 2, that doesn't apply. 3, knowing or in reckless disregard of the fact that an alien has come to, entered, or remains in the United States in violation of law, conceals, harbors, or shields from detection, or attempts to conceal, harbor, or shield from detection such alien in any place, including any building or any means of transportation. Now that is violated. Passing sanctuary city legislation encourages illegal aliens to come to that city to be harbored from detection by the federal government. So Section 3 is violated by any Democrat legislator that enacts sanctuary city legislation. This is the city councils and state legislatures. So Section 3 is violated by any government entity, state or city, that passes sanctuary status laws. It's violating number 3. They're encouraging people to come to the United States, come to the sanctuary city, to be harbored from detection by the federal government, ICE, which is what the state is doing. So 3 is definitely violated here. 4, encourages or induces an alien to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence is or will be in violation of law. 4 is definitely violated. You pass Sanctuary City, it says come live here and we'll protect you, and that 4 violates it. Allowing them to reside in the city, encouraging them to reside in the city, that's a violation of this statute. 5, 1I, engages in any conspiracy to commit any of the preceding acts. Well, legislators getting together to pass laws that violate federal code and encourage illegal aliens to come to, reside, be harbored from in the sanctuary. These are both violations. A conspiracy, V1, 5-1, is violated by sanctuary legislation. Clearly. 5-2 aids or abets the commission of any of the preceding acts. So obviously passing legislation that encourages the violations of law is a conspiracy that aids or abets the commission of those violative acts. So 3, 4, 5-1, and 5-2 are all being violated by the Democrat legislators, the politicians that pass sanctuary city laws. And what does it say will happen to them? Shall be punished as provided in subparagraph B. B, a person who violates subparagraph A shall, for each alien in respect to whom such a violation occurs, each alien, every single person affected by the sanctuary status. 1, in the case of a violation of subparagraph A1 or V1. Now we said A1 wasn't violated, but V1 was. Or in the case of a violation of subparagraph A2, 3, or 4, which we said it can't apply, 3 and 4. 2 doesn't, but 3 and 4, in which the offense was done for the purpose of commercial advantage or private financial gain, be fined under Title 18, imprisoned not more than 10 years or both. Well, I don't think you can make an argument that there's a direct financial gain that the legislators are getting out of this, so they're not going to be subject to this penalty of 10 years. Although A4, A3, and 4, and V1 apply technically if you can show financial gain, but I don't think it does. 2, in the case of violation of subparagraphs A2, 3, 4, or V2, be fined under Title 18, imprisoned not more than 5 years or both. So we said 2 doesn't apply, but 3 and 4 do. A3 and 4 do, and V2 is good for a fine and 5 years in federal prison. 5 years, and this applies. It has no limitation of financial gain or anything else. 3, in the case of violation of paragraph A1, 2, 3, 4, or 5, and 3, 4, and 5 all apply, during and in relation to which the person causes seriously bodily injury to or places in jeopardy the life of any person, be fined under Title 18 and 20 years imprisonment. So if you cause bodily injury as a result of the sanctuary city law, it's 20 years of harboring or helping citizens. Okay, let's keep going. Next, we're on, where is this? Where am I? B, I gotta roll down a little bit more. 2, 3, 4, in the case of violation of subparagraph A, 1, or 2, which don't apply. 3, 4, or 5, which all do apply, resulting in the death of any person, be punished by death or imprisoned for any term of years or for life, and fined under Title 18. Now, 4 applies if somebody dies. That's any term of years or for life. Life imprisonment for sanctuary city laws that result in somebody's death, like in Atlanta with what's her name? Okay, I think I hear the first commercial break coming up. This is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and we will be back in 5 with more in just a few minutes. So, where's that break? LibertyWorksRadioNetwork.com. Find your way over and get signed up. Okay, this is Thomas Freed on the Liberty Works Radio Network, and as I was explaining as the commercial break came up, Title 8, Section 1324, it already exists. It already criminalizes the consequences of passing sanctuary legislation, the consequences to the legislators that enact it. There is no reason at all why Pam Bondi couldn't go out and secure indictments in front of a grand jury of every single Democrat legislator that has voted to enact sanctuary city legislation. It is a federal crime. The law exists. Charge the Democrat politicians who are doing this. They have the audacity to blatantly violate federal law and bring in harbor and shelter and shield from detection and conspire to do so illegal criminal aliens. Make them pay the consequences. The laws exist. Why won't you file? They can't possibly take these cases to court. They're dead to rights. They will be compelled to settle by getting in front of the microphone and declaring that the sanctuary city legislation is unconstitutional. And nobody should try to act under it because the federal government has the statutory authority to control these matters, and the state has no business, neither the state nor the city, trying to pass laws to protect illegal aliens, which is a federal matter. Passing sanctuary city laws is a violation of Title 8, Section 1324. Arrest them, arrest them, and prosecute their asses if they won't settle. This is how you stop this nonsense, is you prosecute the crime. They went after trespassers on January 6th and put them down for 2 years. Put these politicians in court. God damn it. What the hell is wrong with the federal government letting these Democrats write law that violates federal law? Title 8, Section 1324, arrest them. Okay, so let's move on. As you know, we've been arguing in the courts for a while now that the federal income tax under the Supreme Court's decision in Moore is completely unconstitutional, and we have a case that's about to go up to the Supreme Court. It's actually been submitted, and I thought I'd read from this brief. See if people like this. This petition arises out of Federal District Court case number where the district court conducted the criminal trial of the defendant, claiming a subject matter jurisdiction of the court to enforce criminal charges against individual defendants under Section 7201 for attempting to evade or defeat a tax wrongfully assessed as a non-apportioned direct tax on income under an alleged authority of the 16th Amendment to tax income directly and without constitutional limitation, and under IRC Section 7212 for an attempted forcible rescue of property that was never seized under the statutes of Title 26 as required by Section 7212, the charging statute. This court's decision, Supreme Court, taken in Moore et al. V. United States, exposes the direct tax jurisdictional claim as erroneous because Moore holds income taxes are indirect taxes under Article 1, Section 8. Therefore, income tax cannot be the non-apportioned direct tax declared by the court to be the jurisdictional basis for the criminal prosecution of the defendant. The trial court wrongfully conducted the entire criminal trial ultra vires because the district court fatally lacked the subject matter jurisdiction to enforce criminal charges for any direct tax against an individual defendant, because direct taxes must be apportioned to the states, Article 1, Section 2, Clause 3, Article 1, Section 9, Clause 4, more supra. The district court fatally lacked the subject matter jurisdiction to try and convict Cromar for an alleged attempt to evade or defeat a non-apportioned direct tax on his own income because no such tax is constitutionally authorized, regardless of the 16th Amendment. But it was a direct tax that was specifically claimed by the court to be the basis for the jurisdiction of the court taken. Jurisdiction was taken by the court at trial under U.S. v. Collins, 10th Circuit, 1990, and under U.S. v. Belize. The defendant has been wrongfully convicted by a district court that lacked the subject matter jurisdiction to conduct a trial to enforce criminal charges against an individual defendant for any direct tax. Now, U.S. Belize, this is the Utah court. U.S. v. Belize was a New Jersey district court decision that this district court in Utah is citing as the constitutional basis for tax. And the appellate court upheld it in U.S. v. Collins, which is the 10th Circuit decision where they say it's a non-apportioned direct tax, which directly contradicts what the Supreme Court said in Moore. Income taxes are indirect, and they said all direct taxes have to be apportioned. We'll get to that. So Collins and Belize was the basis in the district court and the appellate court for claiming jurisdiction to enforce an unlimited direct tax against the defendant under alleged authority of the 16th Amendment to tax directly and without limitation. That's what they did to him. The appellate court inexplicably ignored the fatal defect shown in the record regarding the claimed jurisdiction of the trial court, which was allegedly taken under two opinions of the courts and not under Article 1, Section 8 of the Constitution. But there is no subject matter jurisdiction of the federal courts that is granted or that can be lawfully taken under opinions or a single statute to enforce against individual defendants a non-apportioned direct tax on their own income, as erroneously proclaimed under Collins and Belize and the district court at trial. The lower courts cannot ignore the factual record in the case and violate the Constitution by allowing the conviction by enforcing against Cromar criminal charges based on an unavoidable, unlimited direct tax on his income. Under the Constitution, direct taxes may only be enforced against the several states. Article 1, Section 2, Clause 3, Article 1, Section 9, Clause 4, more supra, and not against an individual defendant like Cromar. Additionally, no restitution from an individual for an unpaid direct tax is allowed for lack of apportionment of the tax to the several states for payment. Finally, because Loper-Bright overturned the Chevron doctrine of regulatory deference, an enforceable liability for tax may no longer be alleged to exist based solely on a regulation rather than a statute. Under Loper-Bright, the underlying statutes now control that determination of a liability for tax under Section 1461. Additionally, after Loper-Bright, the making of a prima facie assessment of tax by an SFR, substitute for return, may not be argued under regulations alone, outside of the statutory authorities that control the making of an enforceable SFR assessment under IRC Section 6020B2. Issue arguments. Issue 1. The federal personal income tax is an indirect tax under authority of Article 1, Section 8, Clause 1 of the Constitution. In Moore et Ux v. United States, 602 U.S. 572, 2024, the court definitively writes that taxes on income are indirect taxes under Article 1, Section 8 of the Constitution, and that indirect taxes are the familiar federal taxes imposed on activities or transactions. That category of taxes includes duties, imposts, and excise taxes, as well as income taxes. U.S. Constitution, Article 1, Section 8, Clause 1, Amendment 16. Now, note here that in Moore, the Supreme Court declared the 16th Amendment was part of the indirect foundation for an income tax under Article 1, Section 8. Okay, but Article 1, Section 8 only authorizes impost, duty, and excise. So if the 16th Amendment makes income part of that, how is it enforced as a direct tax by the trial court and the appellate court? It seem to be reasonable questions, because there's no consistency. The lower courts are violating the Supreme Court, have been since 1916, basically. Thus, the income tax is an indirect tax under Article 1 and is not a direct tax under the 16th Amendment, as erroneously claimed by the trial court in wrongfully convicting the defendant without the subject matter jurisdiction to enforce a direct tax on income against an individual defendant, rather than the constitutionally required several states. Issue 2. All direct taxes must be apportioned. Where are we? All direct taxes must be apportioned to the states for payment in proportion to the last census, as required under the Constitution. With respect to direct taxation, Moore holds direct taxes are those taxes imposed on persons or property, and that the Constitution requires that direct taxes be apportioned among the states for payment. And to be apportioned, direct taxes must be imposed in proportion to the census or enumeration. U.S. Constitution, Article 1, Section 9, Clause 4, see also Section 2, Clause 3. In other words, direct taxes must be apportioned among the states according to each state's population. More super. This is conclusive. All direct taxes must be apportioned to the several states for payment, regardless of the adoption of the 16th Amendment in 1913. The direct tax the defendant was convicted of allegedly evading and defeating was not apportioned to the several states as constitutionally required. The defendant's conviction was therefore ultra vires for the fatal lack of a granted subject matter jurisdiction of the court to enforce direct taxation against individuals, and consequently must be overturned. Issue 3. Issue 3. The federal personal income tax is not a direct tax on income under the 16th Amendment. Under Moore, all direct taxes must be apportioned to the several states for payment. And the federal personal income tax, being an indirect tax, is not the non-apportioned direct tax under the 16th Amendment claimed by the lower courts. Therefore, there is no subject matter jurisdiction of the federal courts that can lawfully be taken by them to enforce criminal charges against individual defendants wherever the charges are derived from an allegedly assessed non-apportioned direct tax on income that can only be enforced against the several states, not individuals. A subject matter jurisdiction to enforce tax law cannot be taken by the federal courts under the 16th Amendment, only under Article 1, Section 8. Nor may jurisdiction be lawfully taken under authority of a statute alone, like Title 18, Section 3231, as erroneously asserted by the Circuit Court in its order and judgment dated September 2nd, 2025, sustaining the defendant's conviction. Okay, I think I hear that second commercial break coming up. We'll be back in 5 minutes with more. Our reading of the Supreme Court petition we're submitting. This is Thomas Freed on the Liberty Works Radio Network. Stay tuned, and we'll be back in 5 with more on Moore. Okay, this is Thomas Fried on the Liberty Works Radio Network. This is the Truth Attack Hour, and let's just get right back into this. What we're doing here is building the case point by point, step by step, using the most recent Supreme Court decision and more regarding both the nature, the true constitutional nature of the federal income tax, which is an indirect tax under Article 1, Section 8, and the fact that all direct taxes are still required to be apportioned to the states for collection. So the court lacks jurisdiction on both counts. It's not been brought to the court as an indirect tax, but rather as a direct one, which it has no authority to enforce against individuals. And if it is a direct tax, it can't be enforced against individuals because it has to be apportioned to the states. So the decisions in Collins and Belize and all the other circuit courts are absolute constitutional fraud. Just like Roe v. Wade was constitutional fraud, just like Korematsu was constitutional fraud, just like Chevron was constitutional fraud, all brought about by a liberal Supreme Court that's been undermining the Constitution and empowering the bureaucracy, the federal bureaucracy, the bureaucrats, the Politburo, the communists, at least the socialists. Okay, let's get back to reading this brief. Remember now, we're building the case step by step about why the income tax has been wrongfully and unlawfully and unconstitutionally enforced in the federal courts since the end of World War II, basically. Let's go on. In Finley v. United States, 490 U.S. 545, 1989, the court provided that to create jurisdiction, whether original or appellate, the Constitution must have given to the court the capacity to take it, and that to the extent that such action is not taken, the power lies dormant. Precedential support for this constitutional requirement exists. The proper establishment of a subject matter jurisdiction to enforce tax law requires more than just a single statute. Quote, in a long and venerable line of our cases, without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is the power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. Ex parte McCardle, 7 Wall, 506, 1869. The requirement that jurisdiction be established as a threshold matter springs from the nature and limits of the judicial power of the United States and is inflexible and without exception. Mansfield, C and LMR Company v. Swan, 1884. The statutory and especially constitutional elements of jurisdiction are an essential ingredient of separation and equilibration of powers, restraining the courts from acting at certain times and even restraining them from acting permanently regarding certain subjects, like enforcing direct taxes against individuals, because they have to be apportioned to the several states. That's exactly what they're talking about. And they cite see United States v. Richardson, Schlesinger v. Reservists, goes on, for a court to pronounce upon the meaning or the constitutionality of a state or federal law when it has no jurisdiction to do so, by very definition, for a court to act ultra vires, is by very definition for a court to act ultra vires. Steel Company, aka Chicago Steel and Pickling Company v. Citizens for a Better Environment, 1998. Federal courts are courts of limited jurisdiction. They possess only power authorized by Constitution and statute, which is not to be expanded by judicial decree. It is to be presumed that a cause lies outside this limited jurisdiction, and the burden of establishing the contrary rests upon the party asserting jurisdiction. In other words, the United States. It's up to the United States to prove under the Constitution they have an authority to tax directly and without limitation. And they can't do that, and they've never been able to do that. Even under the decisions of the circuit courts, which said it's a direct tax without limitation since 1980, before the Moore decision contradicting that, even then they couldn't prove it, because in order for a power to be enforceable in the court has to be able to show that Congress was constitutionally authorized to write the law. And if the 16th Amendment authorizes a new power to tax directly and without limitation, well, that certainly is a new power, because previous all direct taxes had to be apportioned. So in order for the courts to be able to enforce a non-apportioned direct tax, which they've been doing for 50 years, they would have to be able to show that there is an enabling enforcement clause in the 16th Amendment authorizing, constitutionally authorizing, the United States Congress to write the law that had been brought to the court to try and enforce the non-apportioned direct tax. And of course, there is no enabling enforcement clause in the 16th Amendment, so the courts can't show that Congress was ever constitutionally authorized to write law to enforce or administer or impose any such tax. And failing the ability to show that Congress was constitutionally authorized to write law, they lack the jurisdiction to enforce it, whether the Supreme Court says it's indirect or not. And of course, they've been violating the Constitution for 75 years, telling the American people to sit down, shut up, and do what you're told. We rule you now. To hell with due process. You didn't figure that out from Korematsu when they locked up all the Japanese during World War II? Well, they did the same thing with the tax in 1955. And they've been unconstitutionally enforcing it on the American people ever since. And these cases prove it. And the 16th Amendment proves it. Because it is required to establish jurisdiction. 1, a constitutional power must be granted. 2, the Constitution must give Congress the authority to write law to enforce the power granted. That's why there's an enabling enforcement clause in Article 1, Section 8. It's Clause 18. To authorize Congress to write law for all the powers granted by Article 1, Section 8, Clause 1, including the power to tax indirectly by impost, duty, and excise, and the power to tax directly when apportioned to the states for collection and payment. Without apportionment, there's no jurisdiction to enforce a direct tax. Issue 4. The case record shows the district court erroneously claimed a subject matter jurisdiction under the 16th Amendment to enforce a non-apportioned direct tax on income against the individual person of the defendant. The error in the record in the district court is clear. The district court claimed in hearings that its subject matter jurisdiction to criminally prosecute the defendant was allegedly taken under 2 opinions of the lower courts, asserting authority under the 16th Amendment to tax income directly and without limitation, i.e. Collins in the 10th Circuit and in the Jersey District Court decision invoked by the trial court as United States v. Belize, 2018, Westlaw 2357750, page 3, May 23rd, 2018. Okay, well now, surprisingly enough, I'm quite familiar with Belize because I argued that case for Michael Belize in front of that corrupt judge in New Jersey who made up his own frigging law. He said the new power to tax income directly and without limitation was enforced under the original necessary and proper enabling enforcement clause of Article 1, Section 8, Clause 18, thereby making Clause 18 violate Article 1 by allowing a non-apportioned direct tax. Now, if the Article 1 enforcement clause is going to enforce anything, it's the Article 1 provisions. The 16th Amendment needs its own enabling enforcement clause. The judge in New Jersey knew he was beaten, and this lying pig just made it up. And the Utah District Court judge couldn't find anything else. Though he cites a New Jersey District Court to take jurisdiction, not a constitutional authority, not a decision of the Supreme Court, a New Jersey District perverted socialist pig who just made it up. It's seditious treason from the bench. The judges are your enemy. They're just making this crap up and then acting like they're God and you're a rock that somehow manages to bleed money. Let's go on. The subject matter jurisdiction of the district court cannot be taken to enforce an unlimited direct tax under any number of lower court opinions, nor under any statute, as that unlimited direct taxing power is constitutionally ungranted. In all criminal tax cases, a specific constitutional power to tax must be disclosed on the record in order to fully establish the subject matter jurisdiction of the trial court. The record shows that the trial court erroneously claimed a subject matter jurisdiction to enforce a non-apportioned direct tax on income under the 16th Amendment. That was fatally erroneous because Moore says all direct taxes must be apportioned to the several states for payment in proportion to the census, and that income taxes are indirect taxes under Article 1, Section 8. Therefore, there is no unlimited direct taxation of income that is authorized under the 16th Amendment, as was improperly asserted by the district court in claiming its alleged jurisdiction under the opinions of Collins and Belize in order to prejudicially engineer the ultra vires conviction of the defendant by a wrongfully instructed jury without the subject matter jurisdiction to do so. Issue 5. How long is this? Well, we might get through it. Probably not. Issue 5. Under the Constitution and Moore, the federal courts lack the subject matter jurisdiction to conduct tax trial of individuals, to enforce against them the payment of a non-apportioned direct tax on their own income under an alleged authority of the 16th Amendment to tax directly and without limitation. Under Moore, the district court fatally lacked the subject matter jurisdiction to enforce against the individual person of the defendant criminal charges based on an alleged, unavoidable, unlimited, not apportioned direct tax on his own income, which may only be enforced against the several states. The jurisdictional error is fatal to both the criminal conviction of the defendant in this case and to the previous civil judgment against him in 2017, out of which count 3 arises in this case, because under the Constitution, the income tax is an indirect tax under authority of Article 1, Section 8, Clause 1 of the Constitution. Quote, duties and imposts are terms commonly applied to levies made by governments on the importation or exportation of commodities. Excises are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. The requirement to pay such taxes involves the exercise of the privilege, and if business is not done in the manner described, no tax is payable. It is the privilege which is the subject of the tax, and not the mere buying, selling, or handling of goods, or earning of money. Flint v. Stone Tracy, 220 U.S. 107, 1911, 2 years before the 16th Amendment. Okay, it sounds like we're coming up on the end of the show. I'm going to continue with this reading of the petition next week, and we'll pick it up there. This is Thomas Freed on the Liberty Works Radio Network. I want to encourage you again to find your way over to the taxfreedom.com website and start reading, get educated, because every single tax case, civil and criminal in the country, can be argued on these briefs. Every single one. They're doing the same thing in every single court.